put this up here one more time.
I believe I pressed it there, Lynn.
Got it? Okay, alrighty.
Yes.
All right. Welcome everyone once again to Bonding Education Program class number 6. Thank you for everyone who's joined us. And with that, we will go on to our next speaker. Feel free to go ahead and share your PowerPoint. Mike.
Mike, I think you're on mute.
Yep. Thank you, Sonia, John Paul. So as they both mentioned, I was tasked with going through some practical issues and pitfalls that you see in joint ventures on actual construction projects. And so the scenarios that I have outlined are both actual scenarios that have happened and then situations where an issue arose and we were able to kind of divert things without getting too far down the dispute resolution road. But, you know, as Sonia and John Paul talked, there are multiple ways to form joint ventures. And in my experience on the practical side, and not the formation side, but the actual operation and dispute side, is that the majority of joint ventures are not separately incorporated, as Sonia indicated, you know, for many reasons. And they aren't really the line item joint venture. They have a tendency more to be a combination or pooling of experience. In certain situations, it's as Sonia mentioned, you know, building a bridge up to the deck and then someone doing the road work. In one of these cases that I'll go through here, it was an entity, big national entity that was not my client, that had the horsepower, the resources, the personnel to do the job, but really did lack the job industry specific type of experience. And so, you know, as with all projects, as with all joint ventures, you know, nobody gets into the joint venture with the idea that it's going to go poorly. Everybody assumes it's going to go well. And so some of the practical issues, practical topics to consider as you are negotiating through risk allocation, indemnification, and various other things for projects are, for instance, subcontractor agreements. The subcontractor agreements are often held in the name of the joint venture, but sometimes not. We had a situation where they were actually held in the name of one of the joint venturers. Another practical thing to do is to have one of the joint ventures use their form contract, and we actually had this situation we'll get to in a minute, and the form contract isn't modified properly. The next concept or practical issue is who is going to engage in negotiations and discussions with the owner. If you get to a situation where you do have a claim, or the owner has a change and they're looking for pricing or some other kind of discussion, how does that work? And who is the entity that's going to be owner facing? Because, and as we'll get to one of these stories, the joint venture really does want to present a united front, both upstream and downstream. And failing to do that can be sort of one of the most dangerous practical pitfalls in operations. Operational rights, and this is one of the issues that Sonia touched on, is who's going to manage the project, who's going to oversee the day-to-day. Claims issues. One of the things that I see and proceed with claims. Some have I don't want to say a no holds barred, but they are regimented and rigid about making sure every single claim is documented. Some have a more lax attitude of developing a good working relationship and sort of relying upon that. And one of the things that you see sometimes in joint ventures is, you know, you have one of the two joint ventures pushing for a more aggressive, more regimented approach, and the other one disagreeing. And this is one of those day-to-day operational aspects that really isn't going to fall into the claim section or the dispute section in your typical joint venture document. And then the last thing is those changes and decisions on disputes, and ultimately, how do you resolve those disputes? There will come a point that a decision is just going to have to be made. And I've seen in a lot of joint venture agreements a real hesitancy to peg that decision-making authority with one of the ultimate partners, but you have to do it. There has to ultimately be a decision maker. So, and as I go through this, the purpose of this really is to sort of spark discussion and questions. And so if you have a question, feel free to jump in on any of these topics, something you've seen, something you're concerned about, feel free to jump in. So the first example I have, and this actually was a real situation. This is the entity, not my client, major horsepower national player. My client is the industry specialist. And so in the project, there was a task for the joint venture to secure builder's risk from the owner. And the way the contract with the owner worked is that the owner would provide the builder's risk policy. And so my client's JV partner discussed it with the owner, got the builder's risk policy into place, and construction starts. And lo and behold, they've, I think they were on floor 3 or 4 of the building, and they have a builder's risk event and a serious flood and significant damage. And we get into the policy, and it turns out that the policy is not a traditional builder's risk policy. It's an extension of the owner's standard commercial property insurance. And as is often the case in commercial property insurance, there's an exclusion for driven rain entering the structure, which is, of course, what happened. I mean, there was an enormous flood event through an uncompleted roof, and it damaged a tremendous part of the construction. And so here we are where we have a contractual requirement from the owner. My client had nothing to do with that particular piece of it. And as we looked into the contract documents about, how would we make a claim, how would we sort of present our side of things and preserve our rights, because, we had nothing to do with that process, we came across the contract, the provision of the contract with the owner that said it was the owner's obligation to secure a builder's risk policy. And so we said, well, this is a contractual obligation of the owner. The owner was required to provide the builder's risk policy. Let's, throw that back over the fence and say to the owner, you were obligated to supply builder's risk in conformance with general industry standard. What you provided did not conform with general industry standard. And so to the extent the insurance doesn't cover it, you're going to be liable. And the big dispute we had was the JV partner was really looking to break into this industry, and they wanted this to be sort of their first, we're going to partner with someone to get our foot in the door, and then we're going to develop a relationship with this entity in an ongoing way. And so we don't want to, rock the boat. And given the vast size difference in the entities, what happened to be a material claim for them, or for us, was really not a material claim for them. And we really did have to get into the governing documents, and we documented the process, sort of pointed out our position, raised our claims, raised our documentation, and preserved our rights. And this ended up working out because the insurance provider paid for a good part of it. And then the owner really did step in at the very end when sort of there was a true up at the completion of the job to cover the delta. And so it ended up not being a problem. But this is an example of a very early on part of the process, really job inception process, that led to an issue a year and a half down the road. So some of the radios got their, someone's unmuted with their thank you. The next situation, GMP contract, and this was more akin to the line item type of joint venture that Sonia was talking about, where JV partner 1 had the expertise in specific area of construction. JV partner 2 was the money. And the initial stages of the job that didn't have anything to do with the specialty expertise were really run by JV partner 2. And so they engage in excavation and earthwork and foundation. And during this whole process, they're encountering unforeseen conditions and unexpected issues. They have subcontractors who aren't doing their job. They're untimely. They have to work extra, and they're arguing they're having to accelerate, but in reality, they're not meeting their productivity quotas. And so during this whole process, when my client really isn't present on the job, I mean, they had a representative there, but they weren't overseeing the day-to-day construction. You had this massive buildup of claims. And what the second JV partner was doing is they were just using up the contingency, right? They looked at the budget and said, okay, well, we have money for this and we're not over it, so we're not going to make any kind of a claim. And so it came time for us to come in and do our work. We get into the first situation where there's a claim. We essentially look at the books and realize that all of the contingency is gone. And we are essentially without any buffer of any kind for any claims, really having to build the entirety of the building. And so you get into a situation where the joint venture is the contract holder for the GMP contract. And so their decision in that whole process to not preserve claims, to not demand compensation for the subcontractors who failed to perform their work, and not pass claims upstream, prejudiced us when we weren't even there. And you get into a situation like this where nobody really was operating outside of the contract, right? There was no provision in the JV contract that says you shall make a claim for compensation if a claim exists, or it shall be negligence or breach of your fiduciary duty if you decide to use contingency. And so we came in this position and we're left without a contingency. Now, at the end of the job, they had a number of other issues that stemmed from work that they were overseeing and also self-performing, which really led to a not insignificant inter-JV claim. And we ultimately used that contingency piece as kind of a negotiating position to allow us to resolve all of our issues. But it's a situation where, I guess our client was a little bit negligent in not overseeing the standard work. But, if you don't own the subsurface conditions and you're at a project and you encounter an unforeseen subsurface condition and it's a compensable situation, anybody who's there is just going to assume that you're making that claim for compensation. And, it just wasn't occurring. The next situation, and this is actually an example of an attempt at efficiency that backfired. JV partner 1 was the majority. My client was the minority, and the majority partner insisted on using all of their documents. They were going to provide the CSIP policy. They were going to do. It was their bonding company, and they basically demanded that all of their forms be used and all of their processes be used. And in the subcontract that the JV signed, they changed the name on the first page. But the notice provision in the contract actually had that JV partner's name, and it specifically said, notice shall not be effective unless it's given by this particular entity. And so we get into a dispute with the owner about whether work is a change, whether it's next, or whether we're entitled to compensation. We say it isn't, they say it is, and they issue a construction change directive. And so my client said, all right, well, this is a change directive. We have to get pricing and cost and impact from all of our subcontractors. I think there were 22 or 23 subcontractors. And so, we say, look, we've got to send this down. And the response from them is, well, we don't want to do that because you're just encouraging a claim. And the point that we were making is, well, this is a this is a change. We're being instructed specifically to do this by the owner. And so, yeah, right? I mean, we want to know what all of the potential costs and impacts and things. We're not necessarily going to agree to pay them, but we want to lock this down and sort of put a box around this issue and say, all right, we've preserved it in compliance with our notice provisions upstream and downstream, and here it is. And they refused. And we actually went to the point where we drafted the notice and then sent, pursuant to the dispute policy, a demand, an internal demand to the other JV partner and said, we demand that you send these. And if you don't, you're accepting all responsibility that came from this. And that moment actually ended up being pretty pivotal in where the project, we could prove sort of schedule wise, that's where the project went off track, and that if rights had been preserved and if we had sort of demanded subcontractor performance and managed properly and things from there, a very significant claim at the end of the project would not have happened. But, you know, there was literally, just because of this single oversight in the contracts and subcontracts, there was literally nothing that we could do to preserve that right. And so we were stuck. So what happens when your interests no longer align? So those are sort of three. Two are real world. One is an avoided issue, but sort of played out for academic purposes, what could and could not have happened. What do you do when you're in a joint venture and your interests no longer align? The project's ongoing, you know, the owner's making allegations or subcontractors are making allegations, and the JV's liability in these situations is at least partially your liability. And so the problem that you have in these situations is there's a disconnect between fault and responsibility. And that is where serious problems arise. If you cannot connect fault and responsibility when you're in a legal dispute, you have a serious problem. And so where you are in a JV is, and there's some technicalities about how you get there, but at the end of the day, if somebody sues the JV properly and names the partners, the JV's liability is going to be the individual partner's liability. So it's not like you're in a typical construction situation, you know, your subcontractor, or you have a particular supplier, or, you know, and you can say, I've definitively done my work. My work is correct. I have proof that my work is correct, and I'm done. And therefore, I've cut my liability off. You can have a situation, and I've seen this before with clients, where you have managed your portion of the JV absolutely correctly, and you've preserved all of your claims and you've documented everything, and your co-joint venture has just done horribly, right? And has really exposed the joint venture to liability. And so, you know, what do? Well, the first thing you do is you want to treat this project like a joint defense arrangement. And lots of people have a tendency to think that because you're in a joint venture together, you know, your interests are always aligned, and therefore any internal discussions, you know, especially if you involve a lawyer, are protected. And that is not the case. The JV entity does exist for legal purposes, and it can get its own consultation. But when you get into a situation where it's JV partner against JV partner, you want to memorialize the fact that, hey, you know, we have a dispute, but we're still proceeding on this project. And so while we have claims against each other, our ultimate interests are aligned. And so my suggestion is that you enter into a joint defense agreement so that you can share your analysis. If you have a claims consultant or an expert or anyone sort of coming in at the behest of your lawyer, you can maintain privilege on that, and you can exchange documentation that relates to the dispute and still potentially protect it from discovery.
Mike, this is Rob. Can you just really briefly explain what a joint defense agreement is in broad terms?
And so a joint defense agreement is just essentially a written document where both parties say, we are separate entities, and although our interests may not be identical, we have aligned interests, and so we're going to sign a document that says we have those aligned interests, and it allows you to share information and maintain an attorney-client privilege over that information, shared as between the parties. Because otherwise, if one party's attorney did an analysis and shared it with the other party, even if they shared it with the other party's attorney, that's a communication with a non-represented party, and it waives the privilege. So when you get into these disputes, the two joint ventures have a tendency to think that, well, it's all the same and it's all going to be okay. And that's really not the case. You really can get into a situation where, in preserving your rights against your joint venturer, you are writing out step by step the claim for everybody who wants to make a claim against the joint venture, and then that's ultimately going to come against you. And so that's the other piece of practical advice is to document your claims, especially if you're the minority member and the majority member is disregarding you or acting in a way that is increasing the exposure to the joint venture. And my recommendation is you not only outline the appropriate course of action, you draft the actual documents, right? We recommend that the joint venture take the following action and send this particular notice, right? And as you're doing all of this, make sure that you are reserving it, as in between the two joint ventures, all of your rights internally. Externally, generally speaking, unless things really, really have gotten bad, you want to toe the party line. You want the joint venture to proceed forward and complete the project to the best of its ability without really broadcasting to the outside world that you have this tremendous internal dispute as between the two of you. If you do that, you're just essentially inviting, especially if you're in the general contractor position, the owner to blame everything on you and subcontractors to blame everything on you, and you get stuck in the middle. And then the last piece of practical advice is, as Sonia and John Paul had mentioned, you want to have a dispute resolution provision. I recommend that you always have that dispute mechanism be something that is confidential, something like mandatory mediation, or, a mandatory internal executive meeting between, certain specific representatives who have decision-making authority. Or if you're going to have an actual dispute, do it in arbitration, so that if you get to a point where it really just has become untenable and you've got to do something, you can do it. You can pursue those claims without calling attention to the existence of the dispute, and without really putting a target on your back of, hey, everybody, we're having an internal problem to the joint venture, and blame everything on that alleged internal mismanagement. So with those practical considerations in mind and sort of some of the real world experience, does anyone have any questions, thoughts, ideas, concerns about practical issues in joint venturing?
Mike, I have a quick question, especially regarding when the two of the joint venturers' interests become in conflict or not aligned. Was that a real life experience that you had in that case?
It was.
And was it? Can you just go into a little bit about what happened? Was it just one joint venture wasn't doing his job adequately? There
were two particular major claims from the owner, and the claims from the owner arose really solely from the conduct of our co-joint venture. And so our position, and this is the whole fault responsibility concept, our position is this is 100% your fault, and 100% your responsibility co-joint venture. The problem is we were a 50-50 joint venture. And so if the owner ultimately prevailed on their claims and sued the joint venture and sued both of the joint ventures, we would be liable for 50% and would be left to sort of have to try and pursue our co-joint venture. And the thing that compounded that problem is, you know, the claims were caused by their ineptitude, right? And their improper management, their lack of knowledge of how to properly run the project for this particular stage of the construction. And so, you know, they couldn't save themselves, right? They was sort of this, you know, you don't know what you're doing, get out of our way, we know what we're doing. And our position really was, you don't, right? I mean, we were the specialty contractor, and in this type of industry, we were pointing out all of these issues that arise all of the time that you have to be aware of, and they just were ignoring it. And so, you know, what we basically said to them, and this is the joint defense agreement, you know, we both have an aligned interest. You know, we think we have somewhere between 10 and 11 months left to finish this project, right? It's a 4-year project. We think we're close to done. It is in both of our best interests to get this project finished and then resolve the dispute between the two of us. But we are going to essentially continue throughout this process as you close it out, and as you continue to ignore us, we're going to continue to give you notice of all of the things that we claim that you're doing wrong and all of the allegations that we have against you. And we did that, right? Throughout the process, we gave the notices, we documented everything. And then when it came time to sort of have that executive negotiation, we had the joint defense agreement, the project was completed. Arguably, we never did get to this point because the dispute with the owner was resolved, thankfully. Arguably, though, all of that information is protected. And so when we walked into the dispute resolution with our co-joint venture, what we basically said to them is, look, you're responsible, and we told you you're responsible. We told you how to fix it, and you didn't fix it, right? And here's 2 giant 3-inch 3-ring binders of all of our correspondence over the past 11 months of everything we told you to do, why you were supposed to do it, how we would have done it, what the joint venture should have done, et cetera, et cetera, et cetera. And you didn't do any of this. And they were really faced with, if we blew the joint defense agreement up, and we didn't, there was no arbitration provision, this was straight out litigation, and filed litigation and attached all of these documents, it was essentially a roadmap for the owner to prevail on its claim against the joint venture. And it was a little bit of a game of chicken, but ultimately, you know, because we had all of this documentation, we'd never gotten anything back from them saying, no, we disagree, or your recitation is wrong. I mean, we essentially had this 11 months of unrefuted documentation. The case went away. You know, they accepted full responsibility and resolved the issue. But it's one of those examples where, when you get into those situations, there's a tendency in our industry in the construction industry to put your head down and finish the project. And in situations like this, where it really is your co-joint venture who is screwing things up, you've got to document it. I mean, document the heck out of it, right? What would you do and why? This is what we recommended to the joint venture and you disagreed, right? It's throughout that whole process, so that at the end, when the project is finished and it's time, you know, to assess fault, that it aligns with responsibility. Does that answer the question?
Yeah, thanks, Mike. That was great.
Does anyone else have any questions? All right, Rob, over to you.
All right, let me share the screen. All right, thanks, Mike. My name is Rob Port. I am a practice in both general complex commercial litigation and in the construction group, pretty much across the spectrum, but I do have somewhat of a specialty in dealing with MBE, DBE, EDGE issues, certification, decertification, things like that. So what I want to talk about a little bit today is the opportunities for the minority and disadvantaged business entities to joint venture with non DBE or MBE certified companies. I think I saw one question in the comments about whether the two different entities can joint venture. Absolutely, they can joint venture, and it's advantageous for the smaller DBE minority-owned business to get the experience and access to larger contracts and projects by joint venturing with larger construction companies. So the first thing I want to talk about is just sort of the concept of figure out what's out there, because there's a lot out there in this field, and what you don't want to do is you don't want to leave any projects on the table, any money on the table, any opportunities on the ground. So for instance, in the state of Ohio in 2020, the state exceeded its minority business expenditure goal for the year. The state spent almost $300 million, $298 million over 314 different certified minority-owned businesses. Of the $190 million eligible transportation funds available for 2020, only 51 million, only 27% were spent. So what's the point? The money is being left on the table, and JVs may offer you a way to get into additional projects. Here's just some statistics for ODOT and over the fiscal year 20 to 22, 15.6% of federally funded highway contracts, 7.87% of federally funded transit contracts for those 3 years. The Columbus Regional Airport had a 3-year goal, 15% set aside for minority or disadvantaged business entities. $2.2 million were spent on the highway, street, and bridge construction just for fiscal year 2 of that contract. An example of one way to figure out what opportunities are out there, this is one example. Fifth Third down in Cincinnati held what they called a diversity, inclusion, support, and connection opportunities for vendor empowerment roundtable. It's a mouthful, but the acronym is DISCOVER. So they had a DISCOVER conference, and the roundtable was designed to bring awareness to upcoming business opportunities for minority and disadvantaged certified construction and property management companies. They will hold and have held several of these roundtables, and it's a good idea to see if you can get involved in these roundtables, or that there's others throughout the state. So it will highlight the opportunities that are included in design, mechanical, electrical, and things like that. Also, you should be aware that the local regions, the localities, the cities, some counties have their own codified MBE, DBE goals. So for instance, here's the city of Cleveland's rules codification. Contracts over $50,000, the department shall use its best efforts to utilize MBEs and FBEs, which in Cleveland speech is the female business entities. In Ohio, ODOT and the federal regulations, it's a WBE, women-owned business, women business entity. They encourage participation in Cleveland's codified ordinances. It says that they encourage participation for MBEs and FBEs and in joint ventures. And the credit they give you is slightly different formula than the credit you'd get under ODOT's rules or the DBE rules for the federal government. So you take your percentage ownership of the MBE or FBE participation and multiply that by the joint venture's participation in the contract. So the reason I just wanted to briefly touch on this is to let you know there are many opportunities out there for MBEs and DBEs to joint venture and get involved in projects, even down to the locality, even down to the city level. So it's something to consider. So now let's switch over to talking about specifically joint ventures with disadvantaged and minority business entities. First, some basic structural requirements for it. One of the members of the joint venture must be a certified MBE, EDGE, WBE entity. And instead of repeating all these words, it is sort of word salad or acronyms over and over again. I'll just put it all under the umbrella of a disadvantaged business entity. So going back to the question that was in the comment section that somebody left, yes, absolutely, you can joint venture with a non-certified company as long as you are one of the entities in the joint venture is a certified Ohio DBE business. Under Ohio rules, the DBE business must control the joint venture. It must control the day-to-day operation, management, decision, and policies. It has to have ultimate control, and that's a quote from the ordinances or from the regulations, ultimate control over the management and operation of the DBE. For MBE, which is a minority-owned business, and WBE, which is a women business entity, that entity has to have a greater than a 51% interest in the joint venture. That's interest in the capital, the assets, and the profits and losses. For an EDGE certified company, which is a disadvantaged business entity, both economically and socially disadvantaged, that threshold comes down to 30% interest in the capital and ownership of the entity. Now for DBE, which is the federal program, there's no specified minimum ownership interest like in Ohio, but at a minimum, the ownership interest should be commensurate with the percentage of the portion of the work that the minority entity is performing. So if the minority entity is performing about 25% of the overall work of the joint venture, then it should own and have an interest, financial interest in about that 25%. It's not a hard rule. It's not going to necessarily affect whether it gets accepted as a joint venture, but as a rule of thumb, it should be at a minimum the percentage. Now, Sonia and John Paul talked about the different types of joint ventures. Some of them are just contractual, some of them are a separate entity. You have options, and that's true. But if you're going to do a DBE joint venture and have that joint venture get DBE credit for the contract in Ohio, the joint venture must have its own separate federal tax identification number. It has to do business under the name of the joint venture. So it has to be a separate entity. Federal law for a DBE, there's a little more flexibility. It can be in the form of a formal or informal partnership or exist as a separate entity. So it's important to know which type of minority certified entity you're trying to get certified for. If it's federal dollars from the US Department of Transportation, then you have more flexibility than if it's a contract just for ODOT for Ohio dollars. So I'm just going to transfer a little bit into now sort of the specific pitfalls that you could see in partnering with DBE. And there are two primary issues I want to touch on. That's the commercially useful function and the issue of affiliation. And I want to look at this from both the perspective of a general contractor and from the MBE or DBE certified company. So in a nutshell, a commercially useful function means that the disadvantaged business entity can't simply be a facade or a front that was put there merely as a placeholder to satisfy the contract's requirements for DBE participation. So for example, here we have a beautiful 3-story looking villa, but if you just scratch the surface, what you see is there's nothing behind it. It's just a painting. And that's the kind of facade that these rules requiring commercially useful function are meant to prevent. They want a company that is going to be doing a real job on the contract. And here are some of the requirements. The work performed by the certified business, it must be necessary and useful. These are words directly from the regulations. Necessary and useful role in the transaction. It must be real and required to complete the contract. It can't be made up busy work. It's got to be the kind of work where there's a market for that kind of work outside of the contract of just the MBE, DBE certification. So you can't just bring somebody on as a placeholder. We hear about this a lot. We represent some larger contractors at the firm. We also represent many non-DBE certified companies, and we hear complaints a lot that these DBE certified entities are being brought into contracts just to get the credit, but without doing real work. Maybe they act as a middleman. Maybe they act as an agent for procurement when you don't really need it and there's not really a market for it. So it's just something to be considered when you're thinking about, and this is really for the certification of the DBE. The problem is, if the DBE is joint venturing with a non-DBE entity, well, I'll get to that in a second. I did get ahead of myself. So what is necessary and useful? Okay, necessary and useful means, as I have up there, being responsible for the work, not just performing a management or a purely back office function. You have to actually performing the work and negotiating price and quantities for materials under the federal rule for the DBE program. You can't be limited to what they call, quote, an extra participant, through which funds are just passed through for the appearance of DBE. It has to be active, responsible, and you have to participate. What that means is that the DBE ownership, whoever's controlling the DBE, has to have the experience, the requisite experience, to prove that they can be responsible for the execution of the work, that they know how to perform the function, whether it's negotiating the prices for materials or determining the quality. You can't have somebody being the 51% or greater owner of a DBE or MBE who doesn't understand the industry. If that happens, you won't get certified in the first place. But if you do get by and you do get certified, and maybe you want to get certified under a different code to perform a different function, then the owner better be somewhat voiced in understanding what the new function entails. Doesn't have to know everything, doesn't have to know every aspect of the business, and can certainly hire people that are more experienced and know the business more, but it can't be somebody who has absolutely no understanding of, let's say, paving, to run a paving company and just say, well, I hired an experienced paver. That won't cut it. They have to have the experience because they have to understand enough to control the business, and control is a significant requirement for DBE certification. So let's get to what happens if the certified business does not perform a commercially useful function. First, the state can revoke your certification as an MBE, which is bad enough. So if you're not, in general, in your business performing a commercially useful function, you can get decertified. But if you're not, if you're part of a JV and you're not performing a commercially useful function, then the expenditures that the contracting party is paying won't count towards the goals, the agency's goals for that project. Now, which ruins the entire purpose of having the DBE for the JV in the first place, right? So agencies can count towards their goals only the expenditures to an MBE or DBE certified business that perform a commercially useful function. Those are the words of the Ohio Administrative Code. It only counts to the expenditures to the disadvantaged entity that performs a commercially useful function. If they're not performing a commercially useful function, then the monies expended to the DBE won't count towards the goal. For the federal regulations for DBE, disadvantaged business entity, again, they count expenditures to the DBE only if the DBE is performing a commercially useful function on the contract. So it's a very important requirement, it's a requirement. In my experience, I've seen plenty of people try to get around it, try to shoehorn in a DBE so they can get credit as a subcontractor, so they can get credit. The contracting agency can get credit, and it turns out that they weren't performing a commercially useful function. They were there only as a facade, and then there's a problem with the contract. So there are, sorry about that. There are three broad categories for commercially useful function that are important here: employees, equipment, and project management. So let's talk about employees for a second. The employees are called, quote, regular employees, who are actually responsible for performing the work. There's an adverse presumption under the federal regulations if the DBE does not exercise responsibility for greater than 30% of the total cost of the contract with its own workforce. So you can't subcontract out, 70% of your work and still think you're going to get DBE credit for it, right? You have to use your own employees for at least 30% of the contract, and they have to be regular employees who would work on any other contracts. Regular employees should supervise and direct the work of other regular employees. Again, what I'm getting to basically is that when you're talking about independent contractors, they don't count. They don't count towards your credit. They don't count to regular employees. And if you're staffing the contract with independent contractors to fill most of the work, you're not going to get credit for your DBE or MBE on the job. So let's talk about equipment, because the business must be in control of the equipment. So what does that mean? Does that mean I can't rent equipment? Do I can't lease equipment? Do I have to own the equipment? Well, no. You can rent and lease the equipment as long as it's a traditional arm's length negotiated lease with a written rental agreement. That's absolutely fine. I see a lot of times where you have, I don't want to use the word affiliated because that's a term of art, but sometimes you have a large construction contractor who sees an opportunity and helps create a minority-owned business, and the large contractor will be a 48% owner, and the minority individual or disadvantaged individual will be a 52% owner, and that's fine. And that's fine that you can do that. But then what happens is the minority-owned business, lo and behold, offices in the same spot as the larger company. All the equipment they use is owned by the larger company. All the back office functionality is from the larger company. In that case, you're either not going to get certified, or I guarantee you will become decertified. A lot of those things you can do. You can share office space. You can share equipment. You can even share employees to a certain extent, as long as there are arm's length rental agreements for the equipment. There's some sort of a lease, written lease at market rates for the office space that you're renting. And if you're sharing back office space, then there should be some sort of a management agreement where you're paying for part of that service. There is no control of equipment, right? If the equipment belongs to somebody else, like a general contractor, another subcontractor, or even the project owner. If you're getting your equipment from either of those people who are working on the project, you better have a written negotiated lease for those equipments. So let's talk about responsibility for supervising, because the DBE with a regular employee must be responsible for actively managing, performing, and supervising the project. And what does that mean? Negotiating prices and profit margins, arranging for the delivery of goods, preparing estimates and bids, determining quality, all the things you would expect somebody with knowledge of their industry and who is managing, is a 51 or greater % owner would do on a project. If you're subbing out all of these functions, or even a majority of these functions, then it's going to be a problem determining that the DBE is actually performing the commercially useful function as opposed to just farming it out to a subcontractor. These are the kind of things that, whether you're talking about Ohio or federal, that they're really trying to crack down on. And I've seen an increase in the last couple of years, I've seen an increased scrutiny on minority-owned and disadvantaged business entities or EDGE certified entities because there are people trying to cheat the system, get in under the radar. And I've seen increased enforcement through ODOT, and I currently have several appeals pending now. I took one, we had an informal dispute resolution process for the decertification of a client of ours, which we won, and she kept her certification. The problem is it's a costly process. It's not quite a trial, but it's a hearing, and you have to prepare for it, and you have to write your briefs, and you have to marshal your evidence. So it's not somewhere you want to get stuck in defending the certification of your company, which in large part defines whether your company can survive if you're a disadvantaged business entity. You want to handle all this stuff up front and make sure you have all your ducks in a row at the beginning. And that way you can avoid these, costly defenses later on. So what are the pitfalls for commercial useful function? I talked about them briefly, but there's lack of expertise. As I said, the 51% or greater owner of the disadvantaged business entity has to have some level of expertise in the field. If the person doesn't have that kind of expertise, you're either not going to get certified, or if you try to expand into other areas, you're not going to get the extra certification for those. And before I get into that, I just want to sort of say, if let's say you're a paving person, you start a paving company and you're a disadvantaged business entity for paving, and that's great, and you get certified, and then maybe you want to get into the business of also reselling liquid asphalt. You get a truck, you get a tanker, you can transfer the product, but you don't really know that much about liquid asphalt, so you really aren't voiced and experienced in getting quotes and figuring out quantities. So you get you sub that out, or you get a temp person or a contractor. You're not going to get certified for the additional code as a reseller of the liquid asphalt. You have time to get that experience yourself. There are certification programs for whatever you want to expand into. You can get certification programs where you can get take a few hours of class for a couple months and get a certification certificate, things like that. Remember, you don't have to be an expert, but you do have to have knowledge and some expertise enough that you understand how to control and run the business. The other issue to look out for purchasing irregularities. In other words, a certified business can't just act as a pass-through entity for the appearance of participation. Purchase agreement might artificially inflate the certified business's participation. It will erode control or independence of a certified business. If some other business receives or pays the bills, that's a red flag, right? For the materials, the supplies, they need to be paid for by the DBE. They need to be ordered by the DBE. They'll also look for mismatches on the product. So what do I mean by mismatch? Maybe the certified business performs little work on the project, or no direct work on the project. And the non-DBE business is performing the vast majority of the work. Maybe the DBE is getting paid out of proportion to the work they're doing. Maybe the certified business subcontracts too much work, more than normal industry practice. And that's sort of the standard that ODOT will look for, is if you're subcontracting, are you subcontracting more than what would normally be industry practice for whatever the industry is you're working in? So these mismatches raise red flags that can cause problems. finally, other red flags that could be that could pop up involve sort of relationships with other business. So what does that mean? Maybe the certified business is really just acting as an agent for another business that's not a minority business and performing their quote commercially useful function, or the certified business works primarily for one other contractor. If you're a certified MBE or DBE or EDGE entity, and let's say 90% of your contracts are with one other company, that's going to raise a red flag with ODOT. It's going to raise a red flag with the U.S. Department of Transportation. And what they'll deem, what they could find, is that you don't control your business. The minority owner doesn't control the business. In reality, this larger general contractor who you're contracting with for 90% of your business is really in control. And control is a primary requirement for DBE certification for the 51% or greater owner. Perhaps another example, if the DBE certified entity has a relationship with the contract owner that does not remain at arm's length. And I talked about this before. If you're getting leases on equipment or leases for office space that are sweetheart deals, right? Low cost leases, no cost leases, free services, that is going to be seen as a potential loss of control by the minority business owner. So these are sort of four large categories to look out for. And that sort of ends the discussion of commercially useful function and the sort of pitfalls you could fall into if you're not paying attention to the requirements and you're really trying to just get, some contractor just wants to get the DBE credit, so they're not really coming in with a DBE entity that's performing the function. The next sort of biggest pitfall, and this is really a sneaky one that could get both the DBE decertified and the joint venture lose its credit on the project, and that's called affiliation. So what's affiliation? Here's the general definition. It's business are affiliates of each other when one control or has the power to control the other. So it's not just control, and this is an important distinction, it's also the power to control, right? And it doesn't matter whether the larger entity or the non-DBE entity or person actually exercises the control, only that they have the actual power to control. And that doesn't mean authority to control as in something written in your management agreement where, let's say, the disadvantaged, let's say a minority individual owns 52% of the company and a non-minority individual owns 48%, which is fine. And let's say there's an operating agreement that says the person who owns only 48% has veto on all decisions. In that case, the minority owner, the 52% owner, would not have control. Even if that other owner, the non-minority owner, never exercises that control, even if it never comes up, as long as he has or she has the power to control it, then the minority owner does not have control of the business. Now that's if it's written. It doesn't have to be written. That was the easiest example. It could also be a de facto power to control. And I brought this up a second ago. If the minority-owned business is doing 90% of its contracts with a non-minority business general contractor, then that's an indication that it's really the general contractor that controls the business for the DBE. And in that case, there could be an affiliation or there could be a lack of control. Again, it's a multi-factor test. Well, what ODOT's going to look at and what the USDOT's going to look at is the totality of the circumstances. Then I'll look at everything. Under the Small Business Administration, in order to be a small business, you have to look at either the number of employees or the gross annual receipts. And this depends on the industry you're in, whether it's number of employees or gross receipts, but it's going to be one or the other. So the next logical question is, number of employees of what? or gross annual receipts of what? So the answer, you would think, obviously, well, it's the SBA business. What are the number of employees, the gross receipts? Well, that's not true, because in some circumstances, and what the language says of the regulations, it's the business and, quote, all of its affiliates. So while you might be an SBA, a small business entity that qualifies under the SBA, if you do 90% of your work with a large general contractor, you might be deemed an affiliate of that large contractor, and they would aggregate both your employees and the gross receipts, and you wouldn't qualify as a small business anymore. So how do we determine, for the purposes of defining whether you're a small business, the number of employees or the gross receipts? Well, that's determined by the primary NAICS code under which the company is certified. Now, under federal, for DBE purposes, the primary NAICS code considers the, like I put up here, I don't need to read it, but it's the receipts, costs, or employees over, a 3-year period, or yeah, that could be a 3-year period, could be a 2-year period. But they look at multiple, your industry, they look at your cost of doing business, where you are, and they look at the most recently completed fiscal year. Under Ohio regulations, the primary NAICS code is the code in which just looking at your gross receipts are generated. So there's 2 different standards, and you should be aware of that when you're looking for certification. Under Ohio, MBE or EDGE or WBE versus federal disadvantaged business entity, DBE. And here's the language in the regulation. This is for the federal program, the DBE, in determining the primary industry in which a concern or a concern combined with its affiliates is engaged. They consider what's in the language above it. I don't need to reread it. So again, combined with its affiliates. Here's an example. This is from the Code of Federal Regulations. Here are the NAICS codes for a couple different industries. For instance, masonry contractors, you can be deemed a small business if your receipts are less than $16.5 million. But it's not just the gross receipts of the company. Again, it's the gross receipts of the company and affiliates. Similarly, for concrete block and brick manufacturing, 500 employees or less to be deemed a small business, but it's not just the business, it's the business and its affiliates. So let's look at joint ventures and 2 issues for joint ventures: common management and identity of interest, to determine if you are an affiliate. When do you become an affiliate? When aren't you an affiliate? So each member of a joint venture must qualify as a small business under the federal rules. And whether you're affiliate, and we're going to talk about 4 or 5 down here, these top 3 aren't necessary, they're not as germane for this talk, but I want to talk about common management and identity of interest. So a joint venture is an association of an individual and or concern with interests in any degree or proportion intending to engage and carry business ventures joint profit over a 2-year period. The 2-year period is very important for DBE under the federal regulations, because if you're a joint venture, if 2 companies have come together contractually to join a joint venture, it's logical to say, oh, well, then they're affiliated. Then we should add their employees together, and we should add their revenue together and see if they still qualify as a joint venture. Well, there's an exception to that for joint ventures. As long as each is a joint venture, they can stay together for 2 years and not be affiliated, where you don't have to add them together. So how does that manifest itself? So if you form a joint venture, you can, this is called the 3/2 rule. You can get 3 contracts over a 2-year period before you start to raise red flags that you're really just one company now who's going to go out and get a bunch of contracts and become a single affiliated entity, if not in name, in practice. So a JV may not submit any bid on a new contract beyond that 2-year period. If you form a JV with a DBE on January 1st of year 1, then after January 1st of year 3, after 2 years, you can't submit another bid, or else you will be deemed an affiliate. And then the certifying agency, whether it's ODOT or the USDOT, will add together your employees and your revenue, and potentially you will no longer certify, the JV won't certify as a small business. And your entity won't certify as a small business either, because they're going to add them together and then determine if you still qualify as a small business. Simply put, at some point, such a long-standing joint venture relationship is going to show, even if it's contractual, some sort of contractual dependence, it's going to lead to a finding that there's a general affiliation between the parties. Again, the 2-year period runs from the first contract award. So it's not necessarily from when you form the JV, but when you get the first award. So what that means is you can form a JV and you can put in bids on multiple contracts within the 2-year period. And you can get awards of multiple contracts. Generally, you don't want to go more than 3 because then it'll start to raise issues with affiliation. But you can, if you bid on a contract in the middle of year 2 or towards the end of year 2, and it takes some time to get the award, you can be awarded the contract into year 3 as long as you didn't apply for that project after the 2-year period. Another issue I want to talk about briefly, I want to touch on, is affiliation based on common management. And this is generally something to consider for the DBE, whether you're in a joint venture or not. If you're in a DBE and you have a manager that is also works for another larger company. So if the other larger company is, like I said before, a 48% owner of the DBE, and the disadvantaged or minority individual is the 52% owner, and let's say there's somebody in the management of the general contractor, the 48% owner is the president of his company and the vice president of the minority owned business. So there's a common management between the two companies. That's going to raise red flags. And if that happens, potentially you could be found to be an affiliate of the larger company. And then for DBE purposes, ODOT will look at combine the revenue and combine the employees, and which could ruin the DBE certification for the smaller company. And the factor to look for when you can have with the common management, because you can still have common management as long as that common manager doesn't have the right or the ability practically to control the DBE. As long as the buck stops with the minority or disadvantaged owner, as long as the ultimate control in any decision is with the disadvantaged minority owner, then that's what's required. So you can share the resources. I don't want to say resources, but you can have the one person engaged in the management of both entities, and it won't destroy the DBE certification requirements as long as the minority or disadvantaged owner has ultimate say over all business decisions. The reason, and there's just, there's a good reason behind this. If you're a small business with a financially or socially disadvantaged individual, the whole goal of these programs is to get people involved in the industry and to diversify and provide opportunity for these types of people to get into the industry. It would help if you have experienced people helping you manage the company, which is fine as long as the minority individual has that final say. The other major category for potentially finding an affiliation is termed affiliation based on identity of interest. Now, identity of interest can fall into a few different categories. Identity of interest can be family, and this happens a lot, where you'll have let's say a parent or parents owning a large contracting company where the kids worked for a while, and then the kids break off, and maybe it's disadvantaged or socially disadvantaged person, or it's a daughter for a woman-owned business, will break off and start their own business. Well, if the daughter is running the disadvantaged business, the women-owned business, and the parents are running the large contractor, and they're working on the same types of contracts or subcontracting with each other, then you could find an identity of interest between the two just due to their familial relationship. And for the purposes of DBE, again, aggregate the employees or aggregate the revenue. That explicitly is for parents and children, and husbands and wives, or married couples in general. So spouses and children-parent relationships of different companies, one a DBE, could be deemed affiliated under certain circumstances if they are working in the same industry, working on similar products, and subcontracting with each other. Another potential identity of interest, which I talked about before, was if a large portion of the DBE's contracts are with one general contractor. And generally the cutoff where it starts to raise red flags is about 70%. So if about 70% of your business as a DBE is with a larger company, it's going to raise red flags, and probably at the next recertification period of your DBE certification, somebody from ODOT might come out and start saying, well, look, I looked at your contracts. It's 80% with this one company. I don't think you have independence. I think you're affiliated. So I could aggregate the two companies together, and you no longer qualify as a small business under the SBA and under EDGE certification. So these are the type of things that, it's a lot to take in. I understand it's a lot, the regulations, both Ohio Administrative Code and the Federal Code of Federal Regulations, are large, voluminous, and serpentine. They mix with each other, they fold over on each other. The Ohio Administrative Code references the Federal Code of Regulations. So it's a complicated web of regulations, but hopefully these sort of high points will help you at least sort of identify things up front. So with that, I'm happy to answer any questions.
Wow. Great presentation. Thank you very much, Rob, and all your colleagues. Any questions from anyone? Feel free to unmute yourself, ask your question, or type it in the chat as well. Righty. If there are no questions, we appreciate your time once again. Hon Lozier, attorneys, and thank you so much for sharing this great wealth of information. I'm sure the attendees will find it very helpful. So you see the contact information, everyone. You can take a screenshot there before we go. Okay, looks like we have one question. Mr. Bobby Boyd, feel free to unmute yourself and ask your question.
Yeah, I have one question in reference to the last segment. So just say if you are MBE or DBE on a project, and you know with the prime contractors, they utilize your information to get the account because it's a point system. And after you've been on the project with them, per se a year or two, they figure out a way to manipulate the system to start self-certifying. What do you do in that regards?
By self-certifying, you mean?
Well, self-serving, I should say. You're still on the account. So here's the example. April 1st, 2018, I was what you consider an embedded MBE on a project. The project is still going on the current date. When the pandemic hit, April 4th, 2020, the prime contractor has stated that they were in the woods, need to reshuffle a few things. I'm very understanding because the whole world was experiencing the same thing at the same time. So here we are, the contract is still going on, but they reduced my days of operation with them from 6 days a week to 1 day a week. And all the way up until present day, this contract is still going on. It was never affected by the pandemic, but it's still going on. And here I am, I'm still doing the 1 day a week because I don't want to be that individual who will be decertified because of not performing. But when I reach out to the various administrations to get some assistance, it's like it just continues to fall on deaf ears.
So there's two things that I would, I'd have to see what your contracts look like and see if there's any contractual remedy you'd have as the first step. The second step, I'd be curious whether or not the contractor you're working for is satisfying its MBE requirements by reducing your participation.
And
Have you brought that up?
I continue to try to bring it up, but as I said, when I reach out, and the contract is held by the Ohio Department of Administrative Services, and
Yes.
as I reach out to them, it's like it's no one for me to talk to because it's like I email them, I do all the forms of communication, and it's no one reaching back out to me. And I know that it's definitely a goal because the first year I was supposed to have been performing 14% of the contract as the embedded MBE. After the first year, after the breakdown, the Department of Administration, the Ohio DAS realized that I was only performing at 11% and told them to increase it. And they had increased it for that next year. However, the year thereafter is when the pandemic transpired. And from there, it went from, it has to be a fraction of a percentage now because not only if it's from 6 days down to 1 day, it's on the day where we do least amount of work.
So, maybe Lynette can help you point you in the right direction. But from my point of view as a lawyer, it would seem to me that there's a problem with the contractor now being in breach of the contractor's agreement regarding the participation for the MBE. There's multiple ways I would, if I was advising to handle it, you could go back to the contractor and say, look, it depends how much hardball you want to play, but look, we're going to have a problem if I go back to, if I'm going to go back to ODOT and say, you're not satisfying your requirements for your MBE participation, or if you can find somebody at ODOT to raise that to directly like you did last time, I would do that. But it seems to me it's a problem for that contractor if they're in breach of their requirements for MBE participation.
And that's what I was thinking as well. So I would definitely take that course and see if I can get some type of ramification, if you will. Like I said, it's been falling on deaf ears, but I'm gonna continue to pursue it as I, continue to engage in because I have other accounts, but this is an account that I've been having problems with, and I just, as you were speaking about the joint ventures and the various roles in which that everyone plays, it just, I wanted to ask that question.
Sure.
The answer.
Thank you.
All right. Any other questions? Feel free to unmute yourself.
I had one for Rob. This is Brandon from CVL.
Okay, go ahead.
It was just about the red flags slide that you had up there when you're going through some of the things that may show some negative energy towards who you're working with. You mentioned that doing most of your work with one prime contractor can raise a red flag.
Yes.
I was thinking, I get what you were saying about how that might look bad, but wouldn't also the benefit of working with less contractors mainly increase your, I guess, comfortability and reliability as far as your reputation working with one company instead of spreading it all around? Or how are you supposed to avoid something like that? Is there a set number of people that you're supposed to be working for in a lot amount of time, or how do you avoid those red flags? Because with me, you know, contracting in the past, I find it a lot easier and more consistent when you end up working with, you know, less primes instead of working all over the place. You kind of can rely on that work coming in, and you know the people there, and it seems to be a little bit more consistent that way. How does that compare to what you were saying about raising a red flag?
Sure, it's a great question. And it's a great question because as I'm hearing you imply, this is how the industry works. You become a DBE or an MBE, you get a good relationship with a prime contractor, and you're off to the races. It's great for the prime contractor because they get a way to satisfy, you know, their MBE requirements on a contract on a regular basis, and you get the relationship. It's great for the MBE because you have a steady stream of work, and that's in my experience how the industry is working out there. There is a tension, and you know, Lynette hopefully agrees with this. There is a tension in that that's not how the program was intended to operate, where you would pair up with a prime and just go off and do all the agreements, that all the projects. It was meant to create opportunity for, you know, a lot of people, and for a lot of people to get experience and opportunities. And the red flag, there's two red flags here when you have lots of projects with one prime, over 70%. One is the control issue. You as the minority or disadvantaged business owner have to have control. That's a quote. That's a word that they use in all the administrative codes. You have to have control. If most of your business is with one prime, ODOT or USDOT can find you don't have control of your business. If you can't live as a company, as an entity, without the prime that you're talking about, that's going to raise a red flag for control. It's also going to raise a red flag potentially, as I just talked about, for affiliation. If you're doing 90% of your contracts with one prime, well then heck, you're basically an affiliate of the prime, and we're going to add the revenue, we're going to add the employees together. Now, I've said that, and that's the tension in the industry, the purpose of the program, and ODOT's requirements and USDOT's requirements. The case I was talking about where I successfully defended somebody, this was a major problem. One issue was it was out in a rural western Ohio county where there weren't many DBEs. There were only 2 or 3, and there's only one in this person's industry. So of course, anybody in that geographic region who needed that service was going to call that person. And by the way, there's only one big prime in that, 5-county region that does that. So yes, a lot of this person's business, 90%, was with this one company, and it was a problem for the decertification. The argument that won the day was you can't fault somebody for finding a need in a geographic area, satisfying that need, and they're not being competition for your DBE services. So that argument, I think, won the day. It was just a fact. They weren't going to find it. If you're up in northwest Ohio, you're not going to say, well, the closest competitor is in Cincinnati. So you're not going to have some trucker come up from Cincinnati and raise the cost of your work just so you don't contract so much with one DBE. So look, there's a tension. I'll just admit there's a tension, and it's just something you should think about, diversifying as much as you can, as much as practicable.
Okay, that makes sense.
Okay, with that, thank you so much. Thank you once again, Robin Hanlosher. We appreciate it. We have your contact information, so any follow-up questions, hopefully the business owners can email you, or they can email us, we can get the question to you. So appreciate it. And with our remaining time, we will go to our next speaker, our final speaker, Mr. Donald Stinson with the Ohio Department of Development. And I will bring up his PowerPoint here momentarily. Okay, great. All right, Mr. Stinson, if you could just say a few words about your background and introduce yourself, please, sir. Thank you. You're on mute, sorry.
Hello, everyone. My name is Donald Stinson Jr., and I am a EEO Contract Program Officer with the Department of Minority Business Development Division. I've been with, you know, that we made the change to development this past fiscal year. We were once with the DAS, Equal Opportunity Division, and now we're with the Department of Development Division. Been with the state for over 13 years, worked in multiple facets in construction, EEO, contract officer as well. I mean, EEO officer dealing with affirmative action and so forth. So over the years, I've dealt with construction, AAEO, and business certification. I listened to the presentation throughout the whole time. And so there's going to be some things that I might skip over because some of it will be redundant and I'm looking at time. But I would like to address a couple of those statements that were made by the audience. One, the person that you want to contact, and I think the gentleman's name was Bob, is that correct? Okay. You want to contact Eric Seabrook.
Okay. Eric, say that Eric,
Eric Seabrook.
Seabrook, okay.
Yes, there's been a change. So it used to be he was the EEO state EEO coordinator, but because of the new law, there really isn't a state EEO coordinator, but he is the chief. And so he can elaborate on that more with regards to your situation with regards to that goal. And I want to make it clear. I don't know. I'm trying not to get too far into it, but you can contact him, and he should be able to assist you, or at least point you in the right direction, or do something about that situation.
Okay, so when I reach out to this gentleman, not to interrupt your presentation, I know we're short on time. Do I just go on the Minority Business Development Division site and find his contact information, or
Correct.
do you have something for me?
Correct. Just go to go to the Ohio Department of Development, Minority Business Division, and his name will be there.
Okay, thank you so very much, and I will do so.
All righty.
I'm going to put his email in the chat too, so while you're
Okay.
talking. So, okay, go ahead.
All right. Next slide, please. What I've outlined is actually the objectives will be to, and I don't want to read the whole law, but I want you to be able to see where you can go to the law when it comes to state of Ohio guidelines on it, according to the Ohio Administrative Code. The previous presenter just graciously covered a lot of some of those, what is stated in those codes. But the law, the purpose, or the agenda, advantages for joint venture concerns. I might not spend a lot of time on that because it's already been stated, but I will point out the difference between the state and federal guidelines. We're going to discuss obtaining certification requirements, how to apply, and document submission. And then our contact information will be the last thing, and that would be my superior, Todd McGonigal. Next slide, please. one of the things that I always share with people is before you do anything, when it comes to certification, whether it's JV or our MBE, EDGE, WBE, VBE, always go and look or review what the law states first, because that's what governs us, the Ohio Administrative Code. That's what we look at. And so when it comes to joint venturing, you can see right there that the code is 123:2-14-05. And that is a whole entire outline that will guide you through when it comes to getting certified for joint venture. Next slide, please. And like I said, I don't want to read every single law that's here. It's there for your reading at your leisure. But basically, just want to make it kind of clear some of the various statements that were made with regards to the different types of joint ventures. We don't really get into that. We have a set guideline or set rules that we follow when it comes to JVs. And our JVs are project specific, meaning that just like they've all stated in their previous presentation, you can go to the next slide. All the previous statements that were made, with the difference between ours is you have to register like a new business. And the individual or the individuals that come together, at least one of them has to already be certified. So therefore, whether it's MBE, EDGE, WBE, someone has to already be certified, meet those guidelines, then they can partner up with anybody. Of course, they mentioned about the advantages of joint venture. Like I said, I don't want to rehash or prolong, but these are some of the things you can read that's already been covered when they in the previous presentation, and all the benefits. I'm glad that they went into detail about the pitfalls, so I don't have to cover that as well. So you can go ahead and go to the next slide. And as you can see, we have similarities in the benefits of and advantages of joint venture. You can go to the next slide, please. They kind of pretty much covered this as well with regards to finances. Everything is the difference between ours is whoever's on that JV, they're responsible for that in its entirety, meaning that it's not 25%, it's not line item, it's not 75%. It's the entire person or company that's been created. They're responsible for everything. Next slide, please. And as, like I said, already stated, you automatically have created a partnership, whether you intended for it to happen or not. These are the things that possibilities that you don't want to happen. And our previous speakers have already shared with us the pitfalls and the dangers of a joint venture. So I don't want to spend a whole lot of time on that. Next slide, please. Now, here's the difference. When it comes to MBE and WBE, and it was touched on a little bit, one of the parties of a joint must be a certified. We know that that's the case. It's right here where it's in bold. It says certified company cannot have less than 51% profit and investment ratio, meaning that when it comes to MBE and WBE, the 51% JV, 51% owner of the JV must be that minority individual, and they must put up 51% of the profits and anything else that goes along with it. When it comes to employees, when it comes to finances, so forth and so forth. It's a little different. It's a lot different, actually, when it comes to EDGE. Next slide, please. When it comes to EDGE, all they have to put up is 30%. That's, but they, it's still the same as when it comes to the EDGE individual. they have to, they don't have to put, the 51% owner doesn't have to put up as much. So in other words, a 70% majority, they come in and put in, but the 51% owner only has to put in 30%. Next slide, please. Now, here are all the requirements, and this is straight from the law. So if you go back to Ohio Administrative Code 123:2-14-05, it's going to tell you everything that you need to do under the under the letter B. And all this must be met when you submit your request for certification. So as you can see there, just in the number 3, you must contact the Internal Revenue Service and get a federal tax identification number. So you have to do that. And then you'll see the rest of the order of things that need to be taken care of. Please excuse some of our information. This is still in the law. It has been amended to go over to the development, but you can see at number 19, it says Department of Administrative Service, Equal Opportunity Division. That's still in the law, but it's been changed that all of this is now under development. So some things are still getting worked out. So the wording might cause confusion when it comes to who's responsible for reviewing and looking at these things. As of right now, based on our move in 2021, 21 to development, all of this now is under development. Next slide, please. Here's when it goes to obtaining certification. To facilitate prompt certification, a joint venture agreement may be submitted and approved prior to the issuance of a state bid, proposal, or contract. The coordinator can delay the activation of the date of the JV certification. Basically, what that means is in layman's term, you take care of your responsibilities first based on the previous slide, get that in, and even though the bid or the actual contract that you're pursuing has not started yet, you can take care of all of that and get that to them, and we will review it. The JV certification is only for 1 year. Now, I've seen in the past that although it's for 1 year, it's still project specific, and if that project goes longer, then our director, Eric Seabrook, and others can make those necessary adjustments based on their authority. I don't have that authority, so if you call in and say, Donald, I want to extend it, I would say it's only for 1 year. You would have to talk to my superiors. And as we say, that's a pay grade higher than mine that takes care of those things. As you can see there, if the JV is awarded a contract based on approved joint venture agreement, and as like I just got through stating, exceed 1 year, JV must submit an agreement to DAS each year for recertification. So therefore, that's like I said, sometimes I've seen things happen, not necessarily this way, but I always like to share with people it's best to do things in decency and order so you don't have to worry about the repercussions later. If a JV certification is approved and the JV is not awarded the contract, I've already stated this, the agreement can be revised and submitted for reapproval to meet the new contracting opportunity. Now, here's one that often takes place in construction. It's the material change. If a material change occurs that affects the joint venture agreement as originally approved by the coordinator, then the JV members will provide, and it would not be DAS EOD, but that's what the law states. It would be development with the information dealing with the material change within 30 days of the change. And that's kind of what I was referring to earlier about different changes or if something takes place. As long as you contact the Eric Seabrook some things can get taken care of rather quickly. Uh-oh. Okay. All right. Failure to provide changes to the joint venture agreement may cause to revoke of the certification. So you would hate to be on a project, material change take place, you haven't contacted us, come to find out later on, whatever takes place, the onus is on that individual or that JV because they didn't do their due diligence. Next slide, please. To obtain MBE and EDGE joint venture certification, a certified company must complete an online application via the Ohio Business Gateway. Now, because that system is kind of outdated, so to speak, it's going to tell you to submit to DAS. Please do not send it to DAS-EOD. Please send your supporting documents to DEV -EOD BCCU at the development.ohio.gov. Next slide, please. Here's the contact information as I shared with you earlier. I kind of breezed through this presentation real quick because a lot of things have already been stated, and based on what I've learned over the years, people's attention span over repeated information that sometimes don't always benefit either the speaker or the individual. But here's the contact information should you have any questions. There's our website, and then should you have any further questions, please contact Todd McGonigal at development.ohio.gov. Any questions?
Questions, feel free to unmute yourself and ask your question.
Thank you for your time and all of the information.
No problem. And like I said, the only reason why I didn't go read all that because our time and some have already been presented to you.
Absolutely.
Thank you.
Yes, sir.
Thank you. Great. Hi, Mia. Hi, Jacob. All right, I guess you will close out. You want to just offer some closing remarks and
No, just I'm sorry I wasn't here from the beginning. Again, Jacob Perez here, Great Lakes Region Director for the SBTRC. Thank you to all the speakers for joining us. Yeah, and as well as all the attendees and cohort members. Almost there, right? Last session. I mean, I know these are tough. I know you guys are probably all zoomed out by now, and trust me, man. But thank you again for attending, and looking forward to our last session.
thank you, everyone. All right, I guess we will see you next week, and we're going to talk a little bit about the Bid Express, submitting the bid through Bid Express. So hopefully that'll be informative as well. And thank you, everyone. We'll see you next week, and have a great day. Thank you. Bye.
Bye-bye. Thank you.
Thanks again. Hey, Jacob.
Thank you, Annette.
Thank you.